All right.
Yeah.
Here we are, back in session, as we continue with session 2. And this session 2 will be chaired by Walter Dorald, who teaches at the University of Graz, and who's an incredibly knowledgeable connoisseur of both Austrian and comparative company and business law. As you see me retiring in the back, I'm preparing my synthèse for the end of the conference. So that's why I'm not asking questions. I keep myself out of it. Walter, thank you for picking up this position, and off you go.
Thank you so much, Chris. It's a real pleasure to be here. I can say this, I flinched for a split second when you dropped the word connoisseur, because I thought, oh, I hope he will not wrongly introduce me as somebody who will now give a lecture on Austrian wine. But indeed, having been exposed to German and Austrian legal thinking over my career, this is something that I share with Johannes Flume. It's my great pleasure to introduce you. I will introduce the speakers as they take the floor. Johannes and I, indeed, we share a common past in Berlin for a short period, but also an interest in both legal systems. When you were in Germany, where you did your habilitation, even then, long before you migrated to Austria, you were always interested in Austrian law. You published on it before. You have then been appointed as a chair to Linz initially, and you're now in Salzburg. From what I hear is that Salzburg increasingly appears to be, in the law faculty world, difficult to imagine without Johannes. That is something that makes me very happy. It's closer than Cologne or Berlin. And I think, without further ado, I will give the floor to Johannes. But with one addition, I hope all three of you will be forgiving if I try to be unforgiving about timing.
How much time do I have?
And so, from what I've been told, I would now, of course, be inclined to say you have 10 minutes left, but that is not what we will do. I think we have about 20 minutes per presentation, 20 to 25, and then we'll leave some room for discussion. Johannes, the floor is yours. Thank you.
So, dear colleagues, I'm very flattered to be able to talk to you today. And my dear friend Chris asked me to give a talk on legal persons, directors and officers from a perspective of history of corporate law. Great. So I started to do my homework and worked my way through the, let's call it, evolutionary steps of Austrian and German corporate law. Where could I find any roots regarding the composition of the boards? Well, in a nutshell, Austrian and German corporate law evolved in the, and I'm very strict about saying this was not a German code, but the General Commercial Code of 1861, which was introduced in 37 sovereign states in Central Europe, which is quite amazing to see this as an evolution of law long before the European Union. And for the first time since the Code de Commerce of 1807, it included statutory rules for corporations, or as we call them, Aktiengesellschaft, right? Beforehand, I could talk a lot because I'm in another research topic about global corporations. Beforehand, you just had, Todd has already mentioned it, you had public institutions which were incorporated by charters or octroi. I don't want to bore you here with lengthy details. The rules are quite clear, and there's no indication that the board of directors could be a legal entity rather than the directors of a legal person. It goes without saying that the position of the board in the literature of the time always referred to natural persons. I've looked into several commentaries and so on. There's no indication whatsoever in this 19th century. However, the first reference is to be found in the German Stock Corporation Act of 1937. There you find a sentence introduced at the time: a legal person cannot be appointed as a member of the board of directors. So in 1937, it was for the first time regulated that a board of directors cannot be a legal entity. And as you all know, 1937 was, as we know, a very special time. And actually, this norm also ended up to be law in Austria when during the Anschluss, so-called Anschluss, the Germans octroyed the norm onto Austria. Literary quotations from the period indicates that the exclusion of legal entities from the position of directors was seen as a natural consequence of Hitler's Führer principle spelled out in Mein Kampf. This means that only natural person can assume responsibility and liability as Führer, quote unquote, of the stock corporation. While the influence of Nazi ideology on stock corporation law in 1937 has been well researched, I'm skeptical about how reliable this is in this specific case. The motives underpinning the Act of 1937 can be interpreted more neutrally, because there's one sentence and it states: the activity of board members presupposes personal, or one could say human, involvement. Furthermore, the legal situation has not changed as a result of the ruling in Section 75 of the German Stock Corporation Act of 1937 compared to the Stock Corporation Acts in the German Commercial Code of 1900 and 1861. The requirement was always that it has to be a natural person. Admittingly, a contrasting opinion emerged in the legal literature during the Weimar Republic, but it gained never broader acceptance. This is because, as has been suggested, the board members must be natural persons with legal capacity, since they are personally responsible for the fulfillment of a variety of obligations. The reason is not very difficult to understand, and I don't want to get into more details, as I trust Sebastian and Rolf are doing my job then afterwards, and I don't want to spoil their presentations. On the other hand, I said, now I could stop and I would be happy, and we could earlier go to lunch, because there's nothing more for me to tell you here from the point of legal history. Then I stumbled across a totally unknown dissertation by Helmut Bonder. Nobody of you will heard of it, from 1928. From 1928. And here you can read in the translation: however, it will not be possible to admit the legal person represented by its organs as a member of the board of directors of a corporation, because the organ of the legal person remains bound by the will of its corporation, is therefore not an organ of the corporation, but of the third party, namely of its corporation. That seems to be a relatively savvy consideration. One sees as a mediatization effect here and wants humans to make decisions as board members in the corporation rather than as organs of a third company. Where does this lead us? By building legal entities on top of legal entities in a cascade, you can essentially insert an infinitive chain. But what about the human factor? What about artificial agents in corporate boardrooms? Is it actually possible to exclude humans as active participants from the corporation capacity to act? And now we have talked a little bit, and now it's getting fancy. As you know, there has much been a discussion going about the possibility of which Ponce should have talked about, of introducing so-called self-driving corporations or e-persons. Following the line of thought, Tesla or robo-financial advisor could be viewed as self-driving corporations. So do we no longer need less efficient CEOs, but rather more efficient AI? One does not have to search long to find an explanation and rationale for this approach in form of Otto von Gierke's theory of real entity, reale Verbandspersönlichkeit, which has also gained international recognition through Maitland's translations of parts of this huge work on the Genossenschaftstheory. The relatively simple line of argument is, if corporations have been recognized as real persons, then the same can be done for smart cars, robots, etc. The legal capacity of legal entities is typically explained by contrasting the so-called fiction theory and the organ theory. We have heard this already a little bit. Friedrich Karl von Savigny, the founder of the fiction theory, and Otto von Gierke, the founder of the organ or real entity theory, are often mentioned in the context as great antipodes. More theories regularly being developed and put forward, but I would like to focus on these two as they are particularly relevant to our topics. I refer also here the people to books and writings of Eva. But these two theories can be summarized very briefly as follows. According to the fiction theory, real legal entities themselves do not have the capacity to act or make decisions. They must therefore be represented by a natural person, just like a person who is legally incompetent. In contrast, according to the reality theory, legal entities not only have legal capacity, but also the capacity to act and make decisions through their organs. It is doubtful whether the comparison clarifies the issue of the legal capacity of legal entities. This is because Savigny and Gierke wrote at very different times, and a closer inspection, it seems that Gierke's remarks complement Savigny's. It is often assumed in a gross exaggeration that according to Savigny, the legal entity itself is a fiction, and that Gierke only regards the association, its organs, as social organism. Both characterizations are false. Savigny recognizes the legal capacity of the legal entity, and Gierke considers the legal organs, Gierke calls them in German Rechtsorgane, to be constructed that only exist through legal systems. Furthermore, contrary to what is regularly misrepresented in international literature, it is by no means the case that Gierke recognizes legal entities on the basis of their real existence. Both Gierke and Savigny are aware that until well into the 19th century, cooperation existed only by concession of the sovereign state. Going back to the 17th century and beforehand, as so-called regulated companies can be shown in the 15th and 16th century. Here they take a position very similar to that held in English law since the 17th century and can be found particularly in volume 1 of Blackstone's systems commentaries. In contrast to Savigny, Gierke advocates a system of free incorporation. This, however, became a reality in England, France, Germany, Austria, Austria much later, only in the second half of the 19th century. In Austria, only in the 20th century. According to the explanation in volume 2 of Savigny's system, a legal entity is a legal subject with capacity to hold property. However, Savigny is not yet familiar with corporate organs or boards as we know them today. For him, the subject of attribution are the constitutional representatives. According to Savigny, there is a contradiction to be resolved, and that there is a subject that does not itself has the capacity to actively acquire assets. The same contradiction is also encountered in the case of minors and insane people. According to him, this contradiction is constructively resolved in the same manner. And here I show you the the English translation of the system. Madmen and minors have the similarity with juristical persons, that they are jurially capable, but at the same time they are destitute of natural capacity of action, for which reason of artificial will is produced for them in a person of a representative. These considerations can be applied to current German, Austrian, and Swiss law. In both cases of legal representation by parents and a board of directors, a psychological will is attributed to the minor or the corporation. However, this description of legal attribution of the will of legal representatives is problematic, as it bypasses the internal decision-making process of the board organ or organ. The internal collective formation of will within a corporate organ differs structurally from the psychological will of a natural person. In humans, the psychological will is always part of an external act, such as declaration of intent and part of the conclusion of contracts. If, on the other hand, a decision is made within a collective body, such as a board of directors, it is a matter of decision-making through a formalized procedure that has no counterparts among natural persons. This is where Gierke comes in. He assumes that the collective person is capable of acting. If you look closer to Gierke, he is very precise, contrary to what his metaphor-laden texts and rhetorical exaggerations often suggests. In volume 1 of his German private law, you find here the following passage. The will and non-will of the corporation is determined by the expression of the common will in the resolution of the decision-making bodies appointed for this purpose, die Beschlüsse. Gierke demonstrates how important it is to distinguish between internal decision-making and external execution of resolutions. This formation of will is an internal process that takes place by way of passing a resolution, einen Beschluss. However, the overall will determined by vote must be understood. Unlike the declaration of intent by a natural person, the resolution is not based on a psychological facts. Such a thing does not exist. Rather, the decision is the result of a formalized procedure through which the formation of will takes place in an abstract binding manner within the body. And I found here very helpful the formulation in Article 55 of the Swiss Civil Code. The organs are called upon to express the will of the legal entity. Die Organe sind berufen, dem Willen der juristischen Person Ausdruck zu geben. It's even, how much there left?
About 4 minutes.
Okay, that's fine, because I'm already, now I'm getting again to the fancy stuff. Let's talk about then, for the last 4 minutes, about self-driving corporations. Well, this brings us finally to the concept of self-driving corporations. And I ask you, would it be possible or even desirable to introduce such a corporation? Could the members of the board of the AI be replaced by AI? As we will probably be here in the next 2 presentations, it is undisputed that it's to a large extent not possible in German, Austrian, and Switzerland. However, what if the laws were changed to allow a corporation that trades ETFs automatically, is highly efficient, cost neutral, and has AI replacing the board of directors? As John Armour and Horst Eidenmüller writes, in the medium term, full corporation management by algorithm is most likely to be possible. A great deal of literature, as you know, has been written on this topic. Here, the only issue at stake is whether the question of self-driving corporation can be based on the theory of real legal entities. The rather difficult question is whether Gierke's history theory can be invoked as a robust explanatory model to support this concept. One can read, when an organ acts of a self-driving corporation, there is no representation, but rather direct independent action by the legal entity. And so one could conclude, since there is no need for representation and the entity acts in complete abstract manner, there is no need anymore for humans. Such an approach seems to be, for me, highly problematic for two reasons. Gierke knows of no real association that acts purely on the basis of its social or digital existence. Though this is often described differently, it has absolutely nothing to do with Gierke. Only humans can form a will that is attributed to a legal entity. In other words, external actions by an organ are always the action of a human acting as a director or boards. And here again, Savin and Gierke do not differ in any way. And here we find also a remarkably similar insight in Blackstone's commentaries. Quotation, for a corporation being an invisible body cannot manifest its intention by any personal act or oral discourse. It is the fixing of the seal, and that only, which unites the several assents of the individuals who compose the community and makes one joint assent of the whole. One could object that the latter by pointing out that in regular state, everything is changeable, and that state X could then introduce self-driving corporation. What would be gains? In connection with self-driving corporation, enormous efficiency gains resulting from the automatization are usually referred to. You can read that AI does not sleep, eats, takes no holidays, and analyzes data and Excel spreadsheets like Superman. However, as Susanna Zuboff has pointed out in an impressive essay, we are too quick to disregard the human factor. Susanna Zuboff writes, economists, technology mavens, and CEOs say that the machines will be able to perform nearly all our jobs, and then the impeccable laws of the markets favor replacing people with ever cheaper digital power in forms of robots and algorithms. In the tellings, humans are pitted against the machine in a deadly race. Some of the folks even seem puzzled about what kind of contributions humans can ever make to this robotized future. There is no need to adopt an anti-technology stance. Rather, it's a matter of realistic assessment, the possibility of digitalization in corporate law. And here, in my experience, many lawyers are unfortunately far too naive than technicians. And of course, there's always the temptation to be part of the hype. Certainly, many processes can be standardized to efficiency. However, one should not fall into a kind of a standardization trap. We need humans because of their, not of their perfections, but because of their imperfections, by their ability to respond to non-standardized situation. To paraphrase Max Weber, it's about the irrational in the process of rationalization. Now, despite of saying I'm not interested in any of this, what happens if we introduce this cooperation? The fundamental task, and then there will an end in just a moment, of corporate law has always been to coordinate human activity in an economy based on division of labor. If we recognize self-driving corporations too quickly, enormous problems will be created. Entities would emerge that are decouplable from human actions, even though from a level of international intelligence comparable to the humans does not exist. This is referred to, as you all know, to AGI. These entities would be unable to respond to non-standardized problems and processes. What would you then do? Appoint a human interims manager? In line with Savigny's consideration, we would create an entity impeccable of acting. From a functional perspective, this all has not to do with corporate law, but with using another tradition, strict liability for intelligent systems. Thank you very much.